Today, I, Pranjal Yadav, and my teammate Tanya Singh are presenting a landmark case in Indian legal history, Union Carbide Corporation versus Union of India 1989, a case that changed how India looked at industrial safety, corporate accountability, and environmental law. This case is connected to one of the world's worst industrial disasters, the Bhopal gas tragedy. On the night of 2nd and 3rd December 1984, a toxic gas called methyl isocyanate leaked from a pesticide plant in Bhopal, Madhya Pradesh, owned by Union Carbide India Limited. The gas spread across nearby residential areas while people were sleeping. Thousands of people died within hours. Estimates suggested over 3,000 died immediately, and later more than 15,000 died over time due to complications. Around 5 to 6 lakh people were injured, many permanently. The plant was owned by UCIL, which was an Indian company, but it was controlled by Union Carbide Corporation (UCC), an American multinational company. Soon after the disaster, there was chaos. People rushed to hospitals, animals died, and entire families were wiped out. It wasn't just a tragedy, it was a humanitarian crisis. After the tragedy, many lawsuits were filed in both India and the United States as victims sought justice and compensation. But in 1985, the Government of India passed the Bhopal Gas Leak Disaster Act, giving the government exclusive rights to represent all victims in legal proceedings. Now the case of Union Carbide Corporation versus of Union of India reached the Supreme Court of India in 1989. The key legal issues were: what should be the liability of Union Carbide Corporation for the gas leak? Should the case be tried in India or in the United States? How much compensation should be paid to the victims, and was the amount offered by UCC fair? Can criminal, proceed, can criminal proceedings against UCC and its officials be dropped once a settlement is made? In February 1989, the Supreme Court of India, led by Chief Justice R.S. Pathak, announced its decision. The court ordered Union Carbide Corporation to pay rupees 4,470 crores, which was roughly 470 million US dollars, as full and final compensation to the victims. The court also quashed all criminal proceedings against the company and its officials, meaning no further criminal trials would take place. The court said this case would follow the principle of no fault liability, which means that even if negligence wasn't proven, the company was still responsible to compensate victims because the damage occurred under its control. The judges felt the speeding compensation was more important than prolonged litigation that could take decades. They wanted to ensure the victims received some relief quickly.
The court explained that the sheer scale of the tragedy required a practical solution. It said that while assigning fault might take years, people were still suffering and immediate compensation was essential. However, this reasoning raised concerns. Many felt that the judgment favored the corporation rather than the victim. The settlement amount, 470 crore, was considered grossly inadequate compared to the scale of death and destruction. There was widespread criticism of the judgment. Activists, lawyers, and international observers argued that the lives of Indian citizens were undervalued and that the criminal charges should never have been dropped. In response to public pressure, the Supreme Court reviewed the case again in 1991. It restored the criminal charges against Union Carbide and its officials. However, Union Carbide's then chairman, Warren Anderson, never returned to India. He was declared a fugitive and lived in the US until his death in 2014. To this day, victims and their families continue to fight for better compensation and medical support. This case has a deep impact on Indian environmental and industrial laws. It led to several reforms, including the Environment Protection Act 1986, giving the government more power to regulate industrial safety and pollution. The Public Liability Insurance Act 1991, which made it compulsory for industries handling hazardous substances to take insurance to cover potential damages. It also strengthened the concept of absolute liability, meaning industries engaged in hazardous activities are absolutely liable for any harm caused regardless of fault. This case also became a symbol of the struggle between corporate power and human rights, and a reminder that development without safety can lead to disaster. To conclude, Union Carbide Corporation versus Union of India is not just a legal case, it's a moral lesson. The tragedy of Bhopal changed how India sees industrial responsibilities, corporate ethics, and environmental safety. It remains one of the most powerful examples of why law and compassion must go hand in hand. Thank you.